Hello everyone, this is Anushree Khandelwal and welcome to the Legal Talk series of We Family, episode 3. As promised last time, today we are going to have a discussion on property laws related to buying a property. So if you want to know the various stages involved in buying a property from a legal aspect, then stay tuned. Today we have with us Advocate Anushree Menon, who has years of experience in litigation. After her graduation, she joined an advocate on record in the Supreme Court and since then has regularly appeared in matters before Supreme Court, High Court of Delhi, National Consumer Forums, National Law Tribunal, etc. She has also represented various PSUs, large and medium, and corporates, etc. She has been practicing independently since 2018. Ma'am, we welcome you and we are looking forward to your talk.
Hi everyone. Today we are going to talk a bit about the stages involved in buying a property, but we'll look at it from a legal perspective. Now, at the outset, I must mention what are the acts that come into play when you're buying a property. These are the Transfer of Property Act, the Contract Act, and the Specific Relief Act. Now, after finalizing the property and entering into negotiation with the seller for fixing the price, the first stage that comes into motion is getting into what is called an agreement for sale or a contract for sale. So a contract for sale is nothing but a document which shows that there will be transfer or sale of property at a future date. Now you'll ask me, why is it necessary to enter into an agreement for sale? Why can't I just go on and execute a sale deed? The answer lies is that if you are going to go to a bank to apply for a loan, then the first thing that they're going to ask you is, where is the agreement for sale? So for that purpose, you'll need it. Now, what are the ingredients contained in the agreement for sale? These are nothing but the terms and conditions which the parties have agreed to. That is, it will contain the description of the buyer, the seller, it will contain the description of the property, it will also show what is the consideration. Suppose the property is for 3.5 crores and you've already paid him 50 lakhs for advance, or it's also called an earnest money. So that will also be reflected in the agreement for sale. It will also contain something called a time clause, that is, what is the time within which you are going to pay the balance sale consideration. Say for 1 year. So within 1 year you will pay him 3 crores. It will have also something called a default clause, as in what happens if the buyer backs out or the seller backs out. Normally when the buyer backs out, the seller will usually want to write that I'm going to forfeit your earnest money, I'm not going to pay that back to you. But what happens if the seller backs out? We'll get into that a little later. The agreement for sale will also have a clause wherein the seller will agree to pay up all the dues and the taxes which are pending on the property. You print it out, you print the agreement to sale on a stamp paper, you notarize it. Now the question comes, should I register it? Now it is always advisable that you do register it. It is not necessary, but in what circumstances? We'll get into that. Now suppose after a year you pay up the balance sale consideration and the seller performs as part of the contract. What comes next is the execution of a sale deed. Now please note very carefully that till this time, even though you have paid him the amount, the property still vests with him. He's still the owner of the property. So unless and until you get into or you execute a sale deed and register it at the sub-registrar's office, only then the property passes on to you. Now simply by mere execution of an agreement to sale, the property is not coming to you. That's very clear in section 54 of the Transfer of Property Act. At this juncture, I must also tell you an example that will probably help you understand. Suppose you buy a property from the developer. You shift into the house, you start living there, you are in possession of the house. But the sale deed is still not executed and registered. What happens? He's still the owner of the property and you don't want that. So keep that in mind. I must also tell you that a lot of people are under the mistaken impression that just by executing a power of attorney in favor of somebody else, the holder becomes the owner. That is not the case. There is a line of Supreme Court judgments which say that that is not possible. I thought this could help you. Now, This comes into picture if everything goes well. What happens if you have paid the amount, but the seller says at the end, I am not going to execute the sale deed in your favor? Then you can file something called a suit for specific performance under the Specific Relief Act. Now, what is this? You go to court, you file a suit, and you pray to court. You tell them that, see, I had entered into an agreement for sale with the seller, this particular chap, and I have paid my consideration. He is not ready. Please direct him. Please enforce my contract. This is what you're going to ask. Now, certain sections that come into play for those of you who are interested are section 20, 21 and 22 of the Specific Relief Act. Now, once you file that, the judge has a discretion whether to grant you relief or not. So it's not as if every time you go and you file something, everybody gets a relief. There are certain factors that the judge will take into consideration. That is, what has been the conduct of parties, whether they are ready and willing to perform their part of the contract. Has the plaintiff, that is the person who files the suit, has he suppressed some material facts which he ought to have told the court? After taking all that into consideration and looking at the evidence, that is the cross-examination, etc. of the parties, the judge will decide, it will exercise discretion whether to grant relief or not. Now, at this point, I must tell you what is the limitation time for filing a suit for specific performance. Under Article 54 of the Limitation Act, time for filing a suit for specific performance is 3 years from the time prescribed in the agreement for sale, or 3 years from the date of notice of refusal. Say your agreement for sale says you have to complete the sale within 1 year. Then after the completion of 1 year, you calculate 3 years. That's the time that you have for filing the suit. If there is no time, then what will you do? From the time that he communicates, he being the seller, communicates to you that he is not going to execute it. He'll probably WhatsApp you, text you, call you, or send you an email or a letter. So from that you can gauge when you can actually start calculating the time. It is of extreme importance. Please do not let it go. If you are intending to initiate litigation against somebody, make sure that you do it on time, because if you keep on sitting on it, then what you're losing is the success rate. One of the factors is that. So please keep that in mind. Now I'd like to talk about one or two sections. Now, section 22 of the Specific Relief Act says that you can ask for a refund of the earnest money. That is, you can tell the court that please ask him to pay me back the earnest money that you give. So the 50 lakhs part. Even if you're not entitled to specific relief for whatever reasons, the court can still say, okay, give him back the amount. Now, please note that unless and until you ask the court specifically for this prayer, the judge is not going to grant it. So please make sure that you include this if you so desire. Now, under section 21 of the Act, the Specific Relief Act, you can also ask for compensation. That is, because of the breach of the contract, you have suffered a loss. Then you can ask court to compensate you through the other party. This is what section 73 of the Contract Act says. So there's an interplay between section 22 and section 21 of the Specific Relief Act and 73 of the Contract Act. Now, under section 73, when a suit is filed, it is presumed that the contract has been terminated. It's all over. But under section 21, you proceed as if the contract still subsists. I don't want to get into too much technicalities, but this is what you should know. This also, just like section 22, you must ask the court. You can ask this in addition to your prayer for specific relief, or you can say in alternative to your prayer. Okay, that's up to you. Now, what I explained to you just now is the pre-2018 amendment. This is the pre-2018 position in law. That is the discretion, judge exercise of discretion, you will recall. In 2018, an amendment came that says that now it is not the discretion of the court, it is compulsory that the court grants you specific relief. This, of course, comes in when your case falls into it. So this is something that I wanted to share with you. I hope you all benefited at least a bit from it. All the best. Thank you so much.
Thank you so much, Advocate Anushree Menon. It was really an informative session. If anyone has any specific queries or doubt, kindly email us at wefamilywomen@gmail.com. Until we meet next week with a new speaker, stay tuned. Thank you.